Record.
Hi, everybody. My name is Bridget Kessner, and I'm here from the Connecticut Alliance to End Sexual Violence. This is our second installment of our campus chats and coffee. Today, I'm enjoying some nice coffee out of my big Gemini mug here. And we're going to be talking about Title IX in 2022. So we're going to start by talking a little bit about how we got here, and then despite the fact that there have been challenges to Title IX, how we're continuing to provide support to survivors of sexual violence, and then answering some frequently asked questions. So just to introduce you all to, the topic here of Betsy DeVos. She was the former Secretary of the Department of Education. And if you don't recall the chaos that was her reign, she was the one who thought that we needed to arm all teachers so that they'd be prepared to fight off bears that broke into the classroom. And she was also the one that had proposed some really harmful Title IX regulations that we knew would have a really difficult impact on survivors of sexual violence. So her proposed rules were extremely challenging for survivors. It really restricted who would be able to report depending on what type of sexual violence they experienced, where they experienced it. There were a great deal of student protests, and advocates were really going up to bat to figure out how we could stop this from happening, or at the very least, be prepared to support folks and decrease the harm that we could. So this is Betsy again on her reign of terror. And unfortunately, those final regulations were indeed published to the Federal Register, and they were enacted in August of 2020. Unfortunately, there were still some rather harmful aspects to them that were included, such as off-campus incidents were no longer falling under Title IX, provided the institution didn't have substantial control over the environment that was off campus. It also changed the definition of sexual harassment to be of a much higher standard of severe and pervasive harm occurring to somebody. So there was really a lot going on there. Thankfully, some of the things we were worried about did not happen, but there was still a lot of harm to be done based on her regulations. So as advocates, we all jumped to action to figure out how we could ensure that folks continued to be protected the best that we could. So as we dug through everything, we really found the ways that institutions were still responsible for protecting students, and the ways that students could still find recourse at their institutions and the rights that they still needed to have protected. So institutions are still responsible for preventing and responding to sexual violence. Once the institution has actual knowledge that an incident occurs, meaning that somebody who's responsible under Title IX, what's designated as a responsible employee, comes to find out that an instance of sexual violence has occurred, they must respond, right? So they need to ensure that they are starting to address the incident, usually through speaking to the person that's been impacted, and figuring out what next steps are going to look like in terms of fact-finding or providing accommodations, things of that nature. So if something comes to their attention, they do need to respond. Additionally, here in Connecticut, you'll see there's an asterisk indicating that this is something that's in Connecticut state statute. There still needs to be annual awareness and prevention programming at the start of the school year, throughout the school year, to ensure that individuals know who to go to if they do want to make a report, as well as understand the issue of sexual violence more broadly. Additionally, survivors have a right to support from their institutions. So they should always be offered supportive measures. So this could be changes in housing, work, in their school schedule, support if they're having difficulty in classes. And these are all things that can be implemented no matter what status the investigation is at, because these are things that the student, survivor is doing themselves, right? This is not putting any sort of burden on the party that has been accused. So these supportive measures can always be offered to ensure that that person still has access to their education, and can remove themselves from situations that feel unsafe, and ensure that they can continue to participate in the program that they're enrolled in. Survivors also have a right to go through a process here in Connecticut that is being completed by individuals who are trained in a trauma-informed response. So here in Connecticut, anybody responsible under Title IX needs to undergo regular training to ensure that they're responding in a way that is indeed trauma-informed, to make sure that they're not victim blaming, to ensure they understand the impacts of trauma and why somebody might respond the way that they would. So it's important to understand that that's an aspect as well, that institutions still need to abide by here in the state. Institutions cannot assume that a survivor is lying. So while there is a presumption of innocence that the student who has been accused of the harm has until they are potentially found responsible, we cannot at any point in time at institutions assume that it is something that the survivor has been dishonest about. And if somebody is accused of lying right through a process in which they've reported in good faith, that actually can be considered to be retaliation against the student to make that accusation. So it's definitely a right that needs to be protected through this process. Additionally, the affirmative consent standard that is in Connecticut state statute must be applied to not only our programming, but also any investigations that are taking place. Also, students who are going through an experience of sexual violence, who are going through a hearing, who might be reporting, who want to know what their options look like, have a right to get support from a campus advocate. These are individuals, their roles are kind of spelled out a bit in statute, and we talk about it from our statewide coalition, but these are individuals who are well trained to provide support to individuals going through these processes, so they can really talk to them about what their different options look like and provide support in a variety of ways. And they are always present on college and university campuses in the state. There are MOUs that require them to be involved at those institutions to some extent or another. So every student here in the state should be given access to a campus advocate upon request. Survivors also have a right to different protections. So if there is an instance of sexual violence that takes place off campus, if it doesn't fall under the department's definition of sexual harassment and being severe and pervasive, there are still ways that the institution can protect the survivor, just not under Title IX, unless, of course, the instance does raise to the standards that are laid out in Title IX. There are institutional conduct policies that can still cover these cases. So oftentimes students will still have protection, say if an incident happened off campus, but they're feeling as if their education is impacted and they want some sort of response from the institution, some sort of recourse for what's happened, they can go through that sort of process instead. And that process can actually look rather similar to Title IX. It could be more trauma-informed than a Title IX process. And it's also something that can ultimately result in the same consequence for the person who has done the harm, including ultimately suspension or expulsion. Two-way no contact orders are also an equitable ask that survivors can make. So regardless of the status of the investigation, even if it's at the very beginning stages, students can request that they have a two-way no contact order, so that they can no longer contact the person that harmed them, and the person that harmed them can no longer contact them. And because this doesn't put an undue burden on either party, and rather just requires them not to, have contact with a certain person, this is something that can be appropriately applied at any point in time. Survivors also have a right to fairness. So they have a right to have an advisor. This can be a campus advocate, as I had previously mentioned. This can be an attorney, somebody that they independently find and hire, or it could be somebody from the Victims' Rights Center of Connecticut, which is our program that offers free and confidential legal services to survivors of sexual violence, including those going through a Title IX process. So no matter who they may choose as their advisor, they always have a right to have one through a Title IX process. Additionally, they have a right to engage with a campus advocate through that process. So even if they don't choose that person as their advisor, they still have a right to continue to engage with them, consult with them, and learn about this process from them outside of the hearings themselves. They also have a right to written notification of their rights and options. So what they can potentially do if they have an experience, ways that they'll continue to be protected by the institution, as well as written notification of the ultimate outcome of a hearing or investigation. They also have a right to ongoing support. So even if, say, there's a finding of no responsibility, in a case, a student can still get supportive measures from the institution to ensure that they're achieving access to their education. The preponderance of the evidence standard is used. So essentially that it's more likely than not that the incident of sexual violence did or did not take place. So this standard, the final Title IX regulations did say could be used. However, we here in Connecticut do have a state statute that is still upheld, stating that this is the standard of evidence that must be used in any Title IX investigation and hearing. Survivors also have a right to timeliness. So the investigation process and all of that must take place in a fair and appropriate timeframe. This is not something that should be going on for an extremely extended period of time, of many, many months or years even, given that we know that it's something that is disruptive to someone's education, to their experience at the institution, and therefore we want to ensure that they're going through it in a way that is still, of course, fair and complete, but also in a way that is timely, right? They also cannot put these investigations on hold indefinitely. So if an investigation is being put on hold, a student has a right to know why that's being put on hold, right? And when it will resume. It shouldn't just be an instance where they're told that it's being put on hold and they'll get in touch when it's resumed. Additionally, they must continue to provide these hearings and investigations and all of that despite the ongoing pandemic. So even if there is not, even if there were to be another lockdown, I'm gonna knock on wood that doesn't happen, but this is something that must happen regardless, because it can happen virtually just as well as it could happen in person. These were already happening virtually before the pandemic happened for a variety of reasons. So that's something that does indeed need to continue to take place. A criminal investigation also does not need to impede on a Title IX or campus conduct investigation. There are situations where if there is sort of a conflict between those two to some extent in them taking place at once, that there might be a brief pause, but again, because it cannot be put on hold indefinitely, this is something that a survivor needs to be kind of kept in the loop on, right? Both parties. They need to know why it's being put on hold, when it will resume. And there are a lot of situations where criminal investigation does not actively create a conflict during the ongoing hearing, and therefore both can continue simultaneously. It's also important to acknowledge that the investigation, arrest, outcome, et cetera, of a criminal case, because there are different standards of evidence used, a different process, it's a different sort of space completely. the outcome of that investigation does not need to weigh into the Title IX hearing. So somebody could be found not guilty or even not be arrested in a criminal investigation, but still be held responsible at the college or university where the sexual violence occurred. So survivors have a right to go through a fair process. Survivors and the witnesses in their cases, if they provide testimony, that must be included. So previously it was stated that they had to go through a cross-examination in order for it to be included. Otherwise, what they had shared could not be included on the record. However, due to a memo that came out from the Biden administration in the last several months, this is no longer the case. So if there is testimony that's provided, it can still be included even if there is not an element of cross-examination that takes place later, or a live cross-examination. There can still be questions proposed by the other side, questions they want answered. However, there are different processes that can take place that are not as potentially traumatic as a live cross-examination that can be put in place if somebody does not want to engage. There's also a standard of behavior for hearings that institutions can implement. So because an advisor really can be anyone, and the survivor as well as the accused get to decide who that person is, survivors may be afraid that that is a person that is going to treat them poorly or really grill them during a cross-examination, or if they're being asked questions. But institutions can ensure that there is something on the books stating how these individuals are allowed to behave, and ensure that that is being enforced so that people are not put in a situation where they're uncomfortable like that. Rape shield protections are also provided to survivors going through a process in Title IX. And what this means is that essentially their sexual history cannot be brought up unless it's a matter of attempting to prove that consent was obtained, which there are really only a very, very few cases that I'm aware of where something like that has been necessary to discuss in order to kind of, answer that kind of question, right? For instance, if two individuals who had a regular sexual contact had a signal that signaled that they were going to engage in sexual activity, this is something they mutually agreed upon, and then one individual utilized that signal during the encounter, that is then being investigated. That's a situation where we see that the use of that signal in the past might come up, but that does not mean that any other instances needed to be discussed, nor other aspects of their sexual activity in the past. And then it could also be brought up if they're potentially trying to prove that somebody other than the person accused committed the instance of sexual violence. Again, though, this is not something we see frequently by any means. Survivors also have a right to a fair process in terms of relevance of questions being asked. So it would be unfair to ask them a variety of questions that might not be relevant to the matter at hand. So here are a few frequently asked questions that we get about Title IX and the way that it is currently written and currently enforced. One is, can my campus punish me for drinking or using drugs in these cases? And the answer is no. So here in Connecticut, we actually just got a law passed last year, which was very exciting for us, stating that students who were drinking or using drugs could not be held responsible for that drinking or drug use by their institution as a matter of a student conduct process. If they were, say, underage, or if there is some sort of restriction about drugs or alcohol on campus, and this, of course, ensures that folks feel comfortable coming forward. But it's important to recognize that even where there is not that amnesty provision that we have here in Connecticut, it can still be seen as retaliation if somebody was drinking or using drugs, and then after reporting sexual violence in good faith, the institution decides to hold that against them through a conduct charge, right? So that's protection that students have. Additionally, we have folks ask, do I have to choose between a campus and criminal case? And the answer is no. Again, these are things that can often occur simultaneously. A student can choose one or the other. A student can choose to go through, neither of these cases. Ultimately, it's their choice what they want to do. However, there are different supports that can be provided no matter what their choice might be. Folks will ask, can my institution still help me if this happened off campus? And the answer is yes. So again, there are different campus conduct policies that can cover off-campus cases, and there are still supports, different advocacy resources that can be provided even if this was off campus. So it's important to look at what options are still available and what responsibilities the institution might still have under their own conduct policy. We also have a lot of folks ask, what does a finding of not responsibility really mean? And what it means is really that there was not enough evidence presented in the case to find the accused party responsible for the sexual violence based on the, here in Connecticut, preponderance of the evidence standard. So it does not mean that the institution does not believe that the person experienced sexual violence. Again, if somebody makes that report in good faith, and unless it's a very, very, very rare case of a false report occurring, this is not something that they can hold against them, right? If there's a finding of not responsibility, it does not mean that the individuals didn't believe that person. It just essentially means that when they weighed the evidence, there was not enough evidence to hold that person responsible. So, looking at what's next, we will be going on to week 3 of our series on March 25th, which is Friday at 10 a.m. And that will be about enforcing student rights. Essentially, if students' rights aren't being protected under Title IX, as we just discussed, then what's next? And how can they ensure that their rights are protected or that there's recourse for violated rights? So we're going to be talking through that. If you cannot join us on Friday at 10 a.m. or if you're watching this on our Facebook or Instagram, that will be posted on Monday morning on social media. So keep an eye out for that. And thank you so much for joining us this morning. I hope that you have a great weekend or week, depending on when you're watching us here. And thank you for tuning in to learn more about this topic.